Hi, my name is Paul Norris. I'm a litigation attorney at Stark & Stark. My primary area of practice is probate litigation. And today I'm going to talk about what happens if you're an executor of the estate and the will which you've admitted to probate has been challenged. And what I mean by that is somebody has brought a challenge seeking to invalidate the will, whether it's a beneficiary under a previous will, whether it's a sibling or any other person who may have been a beneficiary under the previous will, seeking to challenge the will you've admitted to probate. First question is, what is the next step you do? Well, the first thing you should do is contact the attorney who drafted the will. That's going to be the main person who is going to assist you in defending this will. And the reason why this is going to be the main person is the attorney that drafted the will is first going to be an essential witness to the case. And this attorney is going to have first-hand knowledge as to discussions with the decedent concerning the drafting of the will and the execution of the will. Now, there's a caveat that you should know, is that this attorney, while important to you, may not be the attorney who can actually defend you. That is only if he has another attorney in his office who can also serve as the litigation attorney for this, because the attorney who drafted the will is in fact a fact witness, and he really cannot serve as a fact witness and the attorney for the estate at the same time. So if that attorney who drafted the will does not have another member in his office, you will have to seek another litigation attorney to assist you. And typically, like I said, the best bet is to contact the attorney who drafted the will, because often he may refer you to another attorney who he has experience working with who can assist you. The next step in the process of defending a will is to determine whether or not the will contest was in fact filed in time. And as I may have discussed in previous blogs, the contest must be commenced within a very short period of time once the will is admitted to probate. And what that means is, for in-state residents, it is a 4-month period of time to contest a will after it's been admitted to probate. It is a 6-month period of time if the individual who's contesting the will is out of state. Either one has a 30-day grace period. So the time to contest a will is very short, so you want to confer with the attorney who drafted the will and the other attorney who you might have retained to see whether the will contest was in fact filed in time. After you've contacted the attorney who may have drafted the will, next thing to do is to start discovering who the potential witnesses are who can support the will. And the witnesses that would be, aside from that attorney, would be people who witnessed the execution of the document. Every will has to be witnessed by at least 2 witnesses, and these witnesses would become essential to discuss whether the decedent understood the will in the time it was executed, and did he appear to be of sound mind at that time. Aside from those witnesses, if the decedent had recently treated with doctors, if the decedent was recently hospitalized, you want to obtain medical records. You want to take a look at the capacity of the decedent, see whether or not there were any issues with the decedent's capacity at the time the last will and testament was executed. That's important because that's almost always going to become an issue during a will contest. What you should know is that typically all counsel fees which you incur in defending the will and representing the will as the executor will be paid by the estate. So you won't have to come out of pocket for counsel fees to defend the will. Once the process is started, typically as the executor of the estate, you can pay your own counsel fees. A person contesting the will, on the other hand, will typically have to pay their own counsel fees unless a successful application is brought at the end of the matter. After you've located the witnesses that we discussed, you should also see whether or not there might be any issues with the witness as far as them being elderly. A lot of times the people who are close to the decedent might be elderly. If that's the case, you might want to take affidavits, sworn statements, or other documents from them to preserve their statements while they're still with you. The next step would be to start to look at what the assets of the decedent were. And this is really kind of a basic thing about defending a will contest. In other words, if you're admitted as executor of the will and it turns out the estate doesn't have a lot of money to it, then it may not be worth it to put forward a $100,000 offense for a $10,000 estate. So it's important to see what's out there. It's also important to know whether or not there were changes to the assets. As the executor of the estate, you're going to have to marshal the assets and determine whether or not there were any changes which might raise a red flag. So that's something you should do as well. But the process of defending a will is something that the attorney, as well as the individual who drafted the will, is going to assist you. It is a complex process. It's going to be an emotional process, as often this process involves disgruntled people, whether they're heirs or family members, seeking to attack, very often, the integrity of the executor, which is often the focal point of a will contest. And if it's not the executor themselves, they're attacking another person who became a main beneficiary under the will, and then once again the finger is ultimately pointed at the executor as to an individual who had something to do with this process. So in the context of defending a will, it's important that you consult with the attorney who drafted the will, the attorney who's going to be representing the estate, because they'll guide you through this process, because the process may involve the retention of expert witnesses, the analysis of medical records, the analysis of financial records. It's typically not something that anybody can handle pro se. And for those reasons, it's suggested that you consult with an experienced litigation attorney to assist you with this process as the executor of the estate, because it's going to minimize the stress and it's going to help to put forward the best defense possible. Thank you for your time.